Part versus Work Relations. Chapter 1. Work Contract. Article 50. A contract of employment is a contract concluded between an employer and a worker, under which the latter undertakes to work under the management or supervision of the employer for a fee. Article 51. The contract must be written in 2 copies, each of which has a copy. The contract is valid even if it is not written. In this case, the worker alone may prove the contract and its rights which resulted from it by all means of proof. Both parties may request to write the contract at any time. The workers of the government and the public institutions shall make the decision or the order of appointment issued by the competent authority the title of the contract. Article 52. This article was amended by Royal Decree No. M46, dated the 6th of May 1436 AH, to be as follows. 1. Subject to the provisions of Article 37 of this law, the Ministry shall establish a uniform form for the employment contract, which shall include the name and location of the employer, the name and nationality of the worker and what is necessary to prove his identity, residence address, including the benefits and allowances, the type and location of the work, the date of enrollment, and the duration of the work if fixed. 2. The contract of employment shall be in accordance with the form referred to in paragraph 1 of this article. The parties to the contract may add other items to it, in a manner not inconsistent with the provisions of this law and its regulations and the decisions issued in implementation thereof. Article 53. This article was amended by Royal Decree No. M46, dated the 6th of May 1436 AH, to be as follows. If the worker is subject to a period of probation, this shall be expressly stated in the contract of employment and shall be clearly defined so that it shall not exceed 90 days. And a written agreement between the worker and the employer may extend the period of the trial, but not more than 180 days. Period of trial excludes Eid al-Fitr and Eid al-Adha leave and sick leave, and each party has the right to terminate the contract during this period unless the contract includes a text giving the right to terminate for only one of them. Article 54. This article was amended by Royal Decree No. M46, dated the 6th of May 1436 AH, to be as follows. A worker may not be placed under probation more than once in the case of one employer, except that by agreement of the parties to the contract, in writing, the worker may be subjected to another trial period provided that he is in another profession or work. If the contract is terminated during the trial period, neither party shall be entitled to compensation and the worker shall not be entitled to end-of-service indemnity for that. Article 55. This article was amended by Royal Decree No. M46, dated the 6th of May 1436 AH, to be as follows. 1. The fixed-term contract of employment shall terminate at the end of its term. If its parties continue to implement it, the contract is deemed renewed for an indefinite period, subject to the provisions of Article 37 of this law for non-Saudis. 2. If a fixed-term contract contains a condition for renewal for a similar period or for a specified period, it shall be renewed for the period agreed upon. The renewal period shall be 3 consecutive times, or the period of the original contract with the renewal period shall be 4 years, whichever is less, and should the parties continue to implement it, the contract shall be transferred to an indefinite contract. Article 56. In all cases where the contract is renewed for a specified period, the period to which the contract is renewed shall be an extension of the original period in determining the rights of the worker to whom the period of service is entered into. Article 57. If the contract is for the purpose of carrying out a specific work, it ends with the completion of the agreed work. Article 58. This article was amended by Royal Decree No. M46, dated the 6th of May 1436 AH, to be as follows. 1. An employer shall not transfer the worker without his written consent from his place of origin to another place where his place of residence is to be changed. 2. The employer may, in cases of necessity that may be required by casual circumstances and for a period not to exceed 30 days per year, assign the worker to work in a place different from the agreed place without requiring his consent, and the employer shall bear the costs of the worker's relocation and residence during that period. Article 59. A worker with a monthly wage may not be transferred to the category of daily workers or workers hired by weekly, piece or hourly wages, unless the worker agrees in writing, without prejudice to the rights acquired by the worker in the period of his monthly wage. Article 60. Without prejudice to the provisions of Article 38 of this law, a worker may not be assigned a work which is substantially different from the work agreed upon without his written consent, except in cases of necessity that may be required by circumstances and for a period not exceeding 30 days per year.